Woman from Washington State, Ms. Delbaney, for 5 minutes.
Thank you, Mr. Chair, and thank you, Director Comey, for spending all this time with us today. In 2010, the White House set up the Vulnerabilities Equities Process, the VEP, and implemented it in 2014 so it could give the government a process for determining whether, how, and when to disclose vulnerabilities to technology companies so that they would be able to address those vulnerabilities and patch them. And in a couple situations, I know there was disclosure from the FBI in April of this year. The FBI informed Apple of a security flaw in older versions of iOS and OS X. Its first vulnerability disclosure to Apple under the Vulnerability Equities Process. In May of this year, the FBI Cyber Division warned the private sector about a fake USB device charger that can log the keystrokes of certain wireless keyboards. And that was 15 months after the FBI discovered the vulnerability. In the warning, the FBI stated, quote, if placed strategically in an office or other location where individuals might use wireless devices, a malicious cyber actor could potentially harvest personally identifiable information, intellectual property, trade secrets, passwords, or other sensitive information, end quote. Other instances of the FBI using the VEP are scarce. And indeed, there have been reports that it's rare for the FBI to use this process. And so I wanted to ask you why this is and what's your view of the process.
Thank you for that question. The process seems to me to be a reasonable process to in a structured fashion, bring everybody who might have an optic on this in the government together to talk about how do we think about disclosing a particular vulnerability to the private sector as against the equities that may be at stake in terms of national security in particular. And so I think it makes sense to have such a process. The FBI participates in it when we come across a vulnerability that we know the vulnerability and that falls within the VEP's jurisdiction. I don't know the particulars of the case. You said there was a 15-month delay in disclosing a particular vulnerability. I don't know enough to react to that. Probably wouldn't react in an open forum in any event, but that's my overall reaction.
And does every vulnerability you discover go through this process in terms of understanding whether or not you would disclose?
I think there's a definition of what falls under the process. You have to know the vulnerability. So we have to have knowledge of, so what is it that allows it, the vulnerability to be exploited? We didn't, for example, in the San Bernardino case. We bought access, but we didn't know the vulnerability, what was behind it. But I forget the definition as I sit here of which vulnerabilities have to be considered.
And so is there another process that you might use that's different from the VEP when you're looking at
I don't know
vulnerabilities and whether
before
or not
the VEP, I know our folks would routinely make disclosure to private entities, but I don't think I don't know of a process outside of VEP.
And so, but you're not sure if in every situation the VEP is used whenever you discover a vulnerability.
Sounds like a circular answer, but if it's and obviously I didn't read the VEP before coming here today. We could get smart on it very quickly and have somebody talk to you about it. But if it falls in the definition of things that have to be discussed at the VEP, of course we do. I just can't remember what that definition is exactly.
Okay, I'm trying to understand if a vulnerability is discovered, if there's always a standard process that you would go through to understand whether or not that information would be disclosed, and if that process is the VEP. Yeah,
that's a great question. I don't know the answer to that, whether there's a set of vulnerabilities that would fall outside of the VEP process, and if that's the case, how do we deal with it? I don't know sitting here.
Thanks. If you have other feedback on that, I'd appreciate it at another time.
Okay.
In August, you said that stakeholders needed to take some time to collect information on the going dark issue and come back afterward to have an adult conversation. And I agree with you. And so I wondered if you would agree that there's room for us to work together on ways to help law enforcement that don't include mandating a backdoor.
Totally. I keep reading that I'm an advocate of backdoors. I want to mandate backdoors. I am not. I have never advocated we have to have backdoors. We have to figure out how we can solve this problem together, and it has to be everybody who cares about it coming together to talk about it. I don't know exactly what the answer is, frankly. I can see the problem, which I think is my job, is to tell people the tools you're counting on us to use to keep you safe, They're less and less effective. That's a big problem. But what to do and how to do it is a really complicated thing, and I think everybody has to participate.
Thank you. Thank you so much for that, and I yield back, Mr. Chair.
Chair thanks the gentlewoman. Recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Well, thank you, Mr. Chairman. I want to start by acknowledging progress. I think it's important that we do so. This morning, we've had 9 straight Democrats talk to the FBI about emails without asking for immunity. That's a record. And I suspect the reason that they have not asked for immunity from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or what witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different, it could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records, which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
There were a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up. And the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interview the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it for this reason. Intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked, and whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information. such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and in what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way
have
to
treated other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand. Because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Yes, you may.
I hope someday when the political craziness is over, you will look back again on this, because this is the FBI you know and love. This was done by pros in the right way. That's the part I have no patience for. Sorry, sir.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director.
And implemented it in 2014. So it could give the government a process for determining whether, how, and when to disclose vulnerabilities to technology companies so that they would be able to address those vulnerabilities and patch them. And in a couple situations, in May of this year, the FBI Cyber Division warned the private sector about a fake USB device charger that can log the keystrokes of certain wireless keyboards. And that was 15 months after the FBI discovered the vulnerability. In the warning, the FBI stated, quote, if placed strategically in an office or other location where individuals might use wireless devices, a malicious cyber actor could potentially harvest personally identifiable information, intellectual property, trade secrets. I know there was disclosure from the FBI in April of this year. The FBI informed Apple of a security flaw in older versions of iOS and OS X. Its first vulnerability disclosure to Apple under the vulnerability equities process.
Woman from Washington State, Ms. Delbaney, for 5 minutes.
Thank you, Mr. Chair, and thank you, Director Comey, for spending all this time with us today. In 2010, the White House set up the Vulnerabilities Equities Process, the VEP,